Welcome again, everyone, and thank you for joining our Farm Succession Planning webinar series. My name is Sylvia. I am the Land for Good field agent. Mike will be presenting and introducing our board member and speaker today, Allison. I just wanted to reintroduce Land for Good. We're an organization that focuses on securing land access and supporting farm transfer. We do that through one-on-one and workshops and education series like this. If you haven't done the poll, please take a chance to do that now and we'll share the results. I want to take a second also to just thank our sponsors for today. Give special thanks to the Vermont Housing and Conservation Board, as well as Northeast SARE. And just a special thanks to our speaker, Allison, for being with us today. And with that, I'm going to hand it over to Mike.
So today we're going to have Allison Poirier from Connecticut, who's an attorney from Connecticut, who's worked with farms down there, who's going to be our presenter, our sole presenter for today. We're going to divide this into three segments. The first segment is going to be about estate planning. The second segment will be more focused on long-term healthcare, and then the third segment will be focused on using business entities to transfer assets in a farm transfer. In each one of those, as we've done all along, please put questions in the chat, and we'll bring those up as it seems appropriate, or when we will take breaks in between each of those segments. So we'll make sure those questions get answered with those segments. And also, if it makes sense, we'll offer the opportunity for people to open their mics at that point if they want to maybe more ask the question directly. And then at the end, we're hoping to have a general amount of time for general questions. And so the last thing I'll say before we get started, a reminder, next week is the last of our webinars. And it's the one I always enjoy the most because it's a farmer panel. And right now I have 6 farmers from 5 farms with all very different scenarios of how their farm transfers have gone or are underway. And so I really encourage you to be there live. And I do encourage people to interact during those as well. So with that, I'm going to hand it over to Allison.
Thanks, Mike, for the introduction. And I also don't hold it against you that this is not your favorite of all the presentations. So I will put my slides back up here. Okay, so as Mike said, I am an estate planning elder law attorney in Connecticut, but I have worked with a lot of farms in terms of their farm succession and estate planning concerns. So I was very happy to be able to participate in the presentation for today. And to dive right in, as Mike mentioned, the presentation is going to be divided up in 3 different sections. So we'll tackle estate planning first. We'll do the long-term care, or also sometimes known as asset protection planning section second, and then focusing on more the business entity portion third. So I always start with all of my estate planning clients, whether they are farm owners or otherwise, with this chart here, just because when we're talking about estate planning, at its core, I find the most important thing to be aware of is what actually will happen to your assets when you pass away. A lot of people have the misconception of, oh, I have a will, so everything's going to pass under the will, or I don't have a will, it's all going to go, up to the government, it's going to go to the state. So I kind of want to dispel all those myths and just walk through this chart because I find it's a really good representation of, well, what actually does happen to your assets when you pass away. So the simple answer is it's all determined by how you own your assets. And the 4 boxes up at the top of this chart are the 4 categories of ownership. The first column on the far left-hand side is for jointly held assets. So this can be assets that you own jointly with your spouse, that you own jointly with your kids, anything that you own in that survivorship form of joint ownership. When you pass away, you can see it's pretty much a straight line down to the bottom of that box that says those assets are going to pass to the surviving co-owner. So it means they don't need to pass through probate. They won't pass under a will. So it can be a really simple and really easy way to transition ownership of assets. Similarly, the second column is for any assets that are passing through a beneficiary designation. And some of the most common examples we tend to see are things like life insurance, retirement accounts, investment accounts, annuities, pretty much any type of financial account that you have that you've put a beneficiary designation on to say, when I pass, it goes to my spouse, or, it goes to my kids in equal shares. If you filled out that beneficiary designation form when you pass away, again, kind of a straight line down to the bottom box in that column that shows those assets get to pass directly to that named beneficiary and also do not have to pass through probate. That changes, that whole simplicity that you get with the joint ownership, that you get with the beneficiary designated assets, changes in the event that you have assets that fall into this third column, which are any assets that you might solely own in your own name. So if you directly own a piece of real estate, if you own your business entity directly in your name, bank accounts, cars, anything that's solely owned just by you without a beneficiary designation on it falls into this third column, which also means it has to go through probate when you pass away. And I'm not sure if anyone here has been through the probate system in their state, but I think even though each state can be a little bit different, the one overarching complaint I've heard about probate from everybody who's ever been through the process is it takes a long time and it can be complicated. And that's a fair criticism because as you can see with this third column here, there's a whole bunch of different boxes here which are designed to represent the various stages of the probate administration proceedings. So it takes a while. To give you an idea of timing, at least in Connecticut, we're seeing a pretty average timeline is about a year. So from the time we submit the will until the time when we're actually able to make distributions out to the beneficiaries, it's a year. And so that's not even accounting from a year from the date of death, because sometimes it takes us, 1, 2, 3 months from the time somebody's passed away to even start those proceedings. So the overall process from when somebody passes to the actual transition of the assets out to the beneficiaries, again, just can take a while. So that's the number one reason why you might have heard people say things like you want to stay out of probate or probate's bad or you want to avoid probate because it's just not simple. It takes longer. So that's why a lot of times I do focus with clients on can we make use of having assets jointly owned? Can we put beneficiary designations on various accounts or different assets? Because it's a really simple, easy way to avoid that whole probate process. But to the extent you do end up in the probate process, you'll notice the very first box underneath that heading says will, because once we're in probate, that's when your will comes into play. So the sole purpose of a will is to think of it as the instruction manual for the probate court for where those individually owned assets are supposed to go. So if you have a will, just be mindful of the fact that it is only going to provide instructions for where your individually owned assets go. It's not going to touch your beneficiary designated assets. It's not going to touch your jointly owned assets, just because the assets first have to be individually owned by you in order to be subject to the provisions in your will. The fourth column on the end is for revocable trusts. Sometimes I've heard these referred to as living trust, inter vivos trust. But the simple answer is a revocable trust is a very common estate planning tool. And the primary use for it is to make sure assets go out, bypass that probate process again. So let's just say you have an asset like a piece of real estate or like the farm business, and you say, gosh, I for one reason or another, I don't feel comfortable putting a joint owner on it. Or maybe it's the type of asset where we're not, depending on the state you're in, we're not even permitted to put a beneficiary designation on it. A revocable trust can be another way for you to own those assets, allow you to retain total control and access to those assets during your lifetime. But then after you pass away, it still provides the instructions for where those assets are supposed to be distributed, but it doesn't have to go through probate. So the distributions happen a lot quicker. All right, so having gone through that now, just be mindful, and something I hinted at just a few moments ago, that almost pretty much any asset that you own can be transferred through a beneficiary designation. Clearly, things like life insurance, like retirement accounts, even your checking and savings account down at the bank, you can put a TOD on those, which stands for transfer on death, which is just another name for a beneficiary designation. In Connecticut, the DMV here even allows us to put beneficiary designations on cars. So it's already on the back of your registration. You fill out the box, and it's another really simple way to keep those assets out of probate too. But real estate can be the one outlier. At least in Connecticut, that's the one asset that state law says we can't put a beneficiary designation on. So if we're just simply looking at this from an estate planning point of view, where we just want to make things simple, we like things to stay out of probate, I can put a beneficiary designation on probably anything you own, but I can't do it with your house or with the farmland. So if we want that to stay out of probate too, we really do have to look at options like having the land jointly owned or having the land owned in a trust. That being said, Connecticut has its laws that said we can't do it, but states like Vermont does permit that. And this is now where I'm going to stop sharing my screen for the moment and turn the mic back over to Mike so you can talk a little bit more about that.
Vermont is unique in New England and much of the rest of the country that we do have one option that many farms will employ if they're not generally if they're not going to use a trust for the transfer of real estate. It's not available in any of the other New England states, or I don't think any other northeastern states. And it's called an enhanced life estate deed, or sometimes referred to Lady Bird Johnson deed, because apparently Lady Bird Johnson had done this with her property in Texas years ago, and this is that name is kind of stuck with it. So you will hear it referred to both ways, or sometimes it just as a transfer upon death deed. And it's designed so that real estate can avoid probate without having to create a trust. In that case, the owner of the property retains full rights of the property during their lifetime, but you name what is called a remainderman, or the grantee, and that can be an individual. Most typically, I see it as an individual or group of individuals that'll be the remainderman, where the property will transfer directly to those people upon death, as you know, because it is a transfer upon death deed. It is so it is exempt from probate, and it is also exempt from Medicaid recovery, which we'll talk a little bit about later if you are using Medicaid for long-term health care, because it's a non-probatable asset. And the as you see on this slide here, that you can go to you can also have it go to a trust or an LLC or business entity. It's not recommended to do that latter part. I'm not exactly sure why, but this is from another attorney here in Vermont. Most commonly, it's to individuals. What we'll often see as well is that or one thing to consider, and we haven't gotten into the long-term healthcare yet, but when there is an exemption for your personal residence in terms of assets for long-term healthcare, and we'll talk more about that. But that's for your home up to a certain value. In Vermont, I think it's like around 770,000. Each state is going to be different, and that's with any contiguous land. So if you you can put your home and this land into the enhanced life estate to have that not be considered. Well, you put it in there, it's not going to be considered for long-term healthcare considerations for Medicaid, but only that land that is contiguous. If you've got other parcels that are separate, those will still be considered. And I don't think that I'm not sure. This is where I wish I had actually, I should have asked the Vermont attorney this question. If you could put those other parcels on enhanced life estate deeds I think you still could put those in there, but they'll still be considered into a separate enhanced life estate deeds. But those other parcels will still be considered for Medicaid. So it won't help with that, but it will allow them to transfer later. So any of you in Vermont, just know that this is an option to consider, instead of just transferring it through a will or transferring it through your real estate through a trust. And speak to a Vermont attorney about that, because they will create the deed and move it into that enhanced life estate deed, so that it will transfer upon death, and you will have to name the remainderman, which I believe you can change at any point, which will be the people it will transfer to later. Hopefully that was clear.
Yeah, and maybe just to mention something too, and something that I'm sure comes as no surprise. I'm from Connecticut, so a lot of what I'm talking about today is based in Connecticut law. I did look up references to similar requirements and statutes for Vermont, just because I know we have a good amount of Vermont attendees today. But this is meant to be general information. Please don't take it as gospel, just because I do highly recommend that if you are considering implementing some of these things, you have questions, you should really be taking those questions and meeting with an attorney in your state just to make sure you're aware of what you actually are and are not permitted to do there. Like Mike had just talked about, in Vermont, we can do these ladybird deeds, but in Connecticut, we can't. So it's just really important to know the specific laws of your state. All right. So for estate planning, generally speaking, so I think the threshold question is still kind of picturing that flow chart in your mind, being aware of how you own your assets. Is that account jointly owned, or is it solely in your name? How is the land owned? Is that owned in just your name? Is it owned jointly? Even if it's owned jointly, you've got to make sure with real estate too, is it actually owned jointly in survivorship, or is it owned as what we call tenants in common, which, yes, there's multiple owners, but it's still deemed as if each individual owner individually owns their separate ownership percentage of the real estate. So just kind of looking at all your assets closely, understanding how you own them, which will also then show you what would actually happen to those assets when you pass away. And then you can make changes based on that. And maybe it's as simple as, oh, I didn't have a beneficiary designation on that life insurance policy or on that bank account. I'm just going to go put one on. Or maybe I put a beneficiary on it, but that was 10 years ago. It should really be updated and I should put someone else on it. So just kind of being mindful of how things are going to pass and potentially making changes. And two, making changes not only, I mean, initially it's maybe you just make changes with how the assets themselves are owned or putting a beneficiary on. A lot of times lawyers aren't involved in that because maybe it's simple as, particularly with something like a bank account, you can go down to the bank and add a joint owner or add a beneficiary. That's really something you can do directly. But the secondary piece of it is understanding that now that I know how my assets pass, maybe I actually do need a lawyer and update my will and my trust because one, maybe I don't have those documents in place. Or I have them, but gosh, we did them when the kids were, little, just make sure guardians are in place and we haven't looked at them in 20 years. So really coming back and revisiting those and say, well, okay, now that everybody's older, now that I know where I want things to go, the documents need to be updated to reflect that. But that means you actually have to figure out what the answers to those questions are. I mean, who are your beneficiaries? Is it as simple as it all goes to my spouse and when we're both gone, it all goes to the kids? Or even if it goes to the kids, is it all the assets 50-50 between the kids or are specific kids getting specific assets? Passing to kids or other beneficiaries, do I trust them enough to be able to just leave it to them outright? Or are they still pretty young? Or even if they're adults, gosh, they're married to someone I know who's gonna divorce them and try to take all their stuff. Maybe I shouldn't just leave this inheritance to the beneficiary outright. Maybe I need some form of ongoing trust to hold that beneficiary's inheritance. So again, kind of really thinking big picture, where do I want everything to go? But then nailing down those specifics of where do I specifically want each of these assets to go and how do I want them to get there? So specifically when thinking about the farm, it's rare, and I'm sure Mike can back me up on this. Even if it's a family farm, we're keeping it in the family. It's almost never that, oh, I have two kids and yeah, they're going to run the farm together and everybody's involved and they want to be part of it. So yeah, everything goes to the kids in equal shares. More often than not, it tends to be one kid is really the front runner, the heir apparent, say, yeah, that's the child that's going to take over the farm. Or maybe you have three kids and two of the kids are really involved in the farm, but the third one isn't. I find more often than not, again, it's not as simple as everybody's going to stay involved in the farm. Somebody usually has decided to, do other things with their life. So it now begs the question of when we're talking about these family farms and passing them along to the next generation, do we want to be fair or do we want it to be equal? Because equal is, I just leave everything to the kids in equal shares. But is that really fair in light of the fact that, well, my daughter's really been the one running the farm this whole time. So why should my son, who's off in California working in the movie business, get a portion of my farm and get a portion of the money when its daughter staying home doing all the work? So you got to figure out what's really important to you. And maybe the answer is yes, maybe even if my non-farming kids aren't really involved in the running of the farm, I still want that. That's really their inheritance. I still want them to have a piece of that. So maybe the answer is yes, just make it equal. Or maybe it is, it really is, it's only fair that the child who's been working this farm for the last 10, 15, 20 years, they really get the farm. And my other non-farming child doesn't, just because, that kid on the farm has really earned it. It's only fair to leave it to them. So you got to always balance the scales and consider, do we want to be fair or do we just want to make it equal? But if you're lucky enough, when you're considering that kind of division of assets, potentially that you have assets in addition to the farm and the real estate. So if you also have investment accounts or life insurance or retirement accounts, and maybe we can have both. Maybe you can say, okay, well, my daughter gets the farm because she's been running the farm and she deserves to have it, but I have enough other assets to balance the scales. So my son can still get the cash and the life insurance and they still get an equal amount of assets. It's just the specific assets they're each getting on paper on value are the same, but not everybody gets a piece of the same assets. And something I feel I always find is somewhat it never ceases to amaze me that when I'm talking about incapacity planning or talking about estate planning, my clients are very comfortable in talking about, if I pass away, here's where things go. Or if my spouse passes away, if my kids passes away, here's the alternates, here's how everything's supposed to go. But then I start talking about incapacity planning, and this is where people tend to pause and go, oh gosh, well, it's simple to think about if I'm just not here, but what if I'm here and I can't do everything for myself? I mean, the farm still needs to be run and my bills still need to get paid and doctors still need decisions. So, I mean, any good comprehensive estate planning should focus, yes, clearly on the transition of assets if you pass away, but should also consider these incapacity planning concerns. And to that end, I would recommend the documents you consider are the powers of attorney, the healthcare directives, sometimes also called healthcare proxies or advance directives, living wills, and HIPAA waivers. And so to get a little bit more into detail about what do these documents actually do. So the power of attorney is solely for financial matters. I need somebody to pay my bills for me. I need somebody to sell my car. I need someone to file my taxes. That is solely falls under the umbrella of the person you appoint to act on your behalf under the power of attorney. With the power of attorney, the more kind of standard and more common form that we use is effective immediately. So a lot of times if you hear people just say it's a power of attorney, it's a durable power of attorney, where I've said, I appoint my spouse first. And if my spouse can't serve, it's, a son or daughter second, things like that. So those types of powers of attorney are effective right away. So even if I'm not incapacitated, I'm fully competent, I'm able to manage my own affairs, but I've signed a power of attorney that says, well, my husband can act, he can go act for me tomorrow. The secondary type of power of attorney is known as a springing power of attorney, which does require me to be actually incapacitated before my appointed agent is going to be able to act on my behalf. And with that springing power of attorney, we have to have some documentation from your doctors evidencing the fact that, yes, you really are incapacitated. Your appointed agent has to sign an affidavit with witnesses, notaries to say, yes, I've gotten the documentation from the doctors. So now I am formally able to step in and act. So, Mike, I didn't know if you had something to add there.
Not specifically on the power of attorney. I do. Well, there's a few things on the healthcare stuff that I want to give, but I will just give emphasis. I specifically made sure every time I've done this to have the attorneys talk about this, because it is where people are thinking so much about the end of life and not thinking about what if I have a stroke or dementia or these other issues that can come up and make all of the rest of these issues much more important.
Yeah, so I would agree, because even if this is, I've had clients who were thinking about this estate planning. We might even been in the process of doing, this farm transfer, figuring out how it's all going to work. But then something happens. There is the stroke, there's a heart attack, there's something which now they're not in a position where they can even follow through on implementing those decisions. But if we have even something as simple as a power of attorney, their agent can now still sign off on those farm transfers, can still sign those deeds, can still create those business entities, and essentially still implement the plan just because we've done this incapacity planning as well. So I agree. These documents are very, very important. I highly recommend that they be in place. And just a quick note on the medical, which is kind of the next three documents are all under the medical context. The healthcare directive, or as I mentioned, sometimes it's called a healthcare proxy. Different states use different names. But at its heart, it's you're appointing someone to make medical decisions for you if you're not able to do so for yourself. And unlike the power of attorney, this does actually require you to be incapacitated before your appointed healthcare agent can act for you, because so long as you can talk to the doctors, or the doctors are talking to you, but it's only if you're not able to respond or they don't feel you have capacity to respond, that's then when they would start asking those questions of your healthcare agent. The living will is a statement of your wishes about either receipt or withholding of care at end of life. Some of my more blunt clients call this the pull the plug language. If I really am in an end of life situation, if I am terminally ill, if I am permanently unconscious, I don't want the respirators, I don't want the feeding tubes, I don't want the CPR. Essentially what it says is that I don't want my life directly taken, but I also don't want it unnecessarily prolonged. So it's meant to be guidance for your appointed healthcare agent if there comes a time where they have to make that decision of, do we try these life-sustaining treatments or do we not? And just last but not least, a HIPAA waiver is access to information. You say my doctors are permitted to talk to my spouse, to my kids, to whomever you want. That's not decision-making authority. That's simply they can gain access to your medical information. And a lot of times, folks may not realize you have this information already directly on file with your doctors, because every time you go in, or if you go in for your annual physical, somewhere down that checklist of information where they say, is this still your address? Is this still your phone number? There's usually a box that says, but can we call somebody else? Can we leave a message for somebody with your information, or to tell them how you're doing? So that's a HIPAA waiver. So even if you don't have this HIPAA waiver form in place, you may also have that already on file with your doctors. But I always say double check just to make sure, because maybe it is kind of like similar when I was talking, you did the will, it was years ago, you don't even remember who you put in there. Same thing with that HIPAA waiver. You might want to check it periodically to make sure the correct people are listed, so they'll be able to gain access to your information.
So a couple of things I wanted to say. One thing that's really important to understand is when your children become 18, you no longer have any say in their medical care, nor do you have any ability to access their records without that HIPAA waiver, right? So that's something that you need to often talk to your adult children about. And I had one story of with a farmer that I worked with here in Vermont, who had a tractor accident, was working too late, rolled his tractor, and he was conscious when they were putting him on the helicopter to fly him to Burlington. And before he passed out, he gave permission. He was in his 40s. He was divorced. He didn't have anybody that was assigned that had any HIPAA, had the HIPAA waiver. Because I think he had assigned it to his wife before he got divorced, but he was back with his parents. And so he told the paramedic before he passed out, and his mother was there. He said, I want my parents to make medical decisions for me, and I want to live. And that, we're lucky that he was conscious, right? Because otherwise it would have created a lot more complications at the hospital without that legal document. So we kind of take that for granted. Again, we often think about this stuff towards the end of life as if that's where it's going to, at old age, as if that's the only time where these issues might come up. I also just wanted to mention, I put into the chat a link to the Vermont Ethics Network that gives guidance and directions on how to set up advanced directives. Vermont has a secure online advanced directive registry that allows doctors throughout the state to access it, because often advanced directives you might have to be assessing them in kind of access them in emergency situations. It's not something everybody is carrying around. And so they have an online registry that you can use, and that directory, that website also provides some guidance. These are legal documents here, but really when you're trying to decide what you want to put in them, it's really something that's a healthcare decision. And so I always encourage people to take these and sit down with your doctor and talk about in your particular situation, which is going to change through your life. And as you may have different diagnoses of different issues, that may, how you view what you want done at a certain age and a certain condition is going to perhaps be different later on. I know that hospitals will sometimes have people on their staff that can sit down with people as well. There was a good program on Vermont Public Radio a year ago, fall of 24, that where they had the discussion. They had a nurse whose job that is at Rutland Hospital come in and talk about that. And so encourage everybody to do that at every age. I've been an EMT for 30 years, and unfortunately, I've seen a lot of unfortunate incidents happen to much younger people than you would expect. And you need to have these documents in place. And I mentioned, I think maybe at the first session, but I just had a 41-year-old farmer friend of mine die in an accident this last fall. These legal documents, you weren't thinking necessarily that these were going to be important in his situation, including the will, guardianship for his children. All that stuff became really important at 41. So, don't wait. And since we have mostly older people here, encourage your younger members of your family to be looking at all of these documents. So I'll leave it at that.
And also, too, once they're implemented, I mean, periodically review these, just because I do find it is really common for folks to have set up these documents. Again, the common situation is we have kids, they're little, let's just hurry up. We got a simple will, we got the powers of attorney. It's now 20 years later, and the people you've appointed to be your healthcare agent and to be your power of attorney are siblings who are older than you and live further away. They're parents that have since passed away. So maybe now it should be those kids coming on and being named as the alternates or primaries. So not only implement them, but I always say every 3 to 5 years, you should be taking these documents out, reading through them, and updating them as needed. All right, and so this is where I'll pause because this is the end of the estate planning section. Does anybody have any questions?
We do have a question in the chat. It sounds like from Maine Farm. However, it's my healthcare directive drawn up by my Maine attorney and signed and witnessed also states my wishes about receiving or withholding medical care at the end of life. Is that not correct? And Vicky, if you want to ask specifically, you can come off mic.
No, so even though I've broken them out in kind of separate sections here, it's really common for the medical, like the healthcare directive, the living will, the HIPAA, that could all be one document. That's not uncommon. So I just wanted to make folks aware that sometimes they are separate forms, sometimes they're all baked in together, but they are these separate components. So I would say the fact that it sounds like the healthcare directive and the living will are combined is really common. And actually, those are the types of forms that I prepare at my firm here in Connecticut.
Yeah, and in Vermont, advanced directives are combined and also include I think in some states it's still called the medical care power of attorney or medical care agent. So the medical care in Vermont, you have the advanced directives, and in that you designate your medical care agent, who will be the person who makes decisions for you. And not to pick on Vicky, but to say to anybody, if you have to ask if that's correct, it's time for you to pull that document out and read and say what does it actually say, and is it time to update it?
Well, this actually just happened all within the last few months. So I am in Maine, and yeah, I don't know. I don't have a living will. So I do have a will, but it's just a plain old will. It's not a living will. It's not a trust of any sort. And I'm working to get that done as well. But every time I take one of these classes, I get 16 different answers. And my lawyer is, well,
I think
I don't know. Yeah.
I think the advanced, what you're saying is that you drew up healthcare directives, which in Maine, if you read what it says, that'll clarify, is it all in one, as it is here in Vermont, where you're not necessarily having a separate living will, as Allison was saying. She's putting these up as these are potential 4 different documents, but here in Vermont, you can have those all combined, including designating your medical care attention, and maybe the same case in Maine. So I think it's really important to just read what you have and just make sure that that's providing for all of what's described in Allison's slide. Allison, did you have anything more to add?
I think it does. I think it does. I mean, but I'll be dead, so it's not going to be my problem. I guess. I'm doing the best I
Well,
can. That's
remember,
all I
this is
can say.
before you
You
die.
know,
This is before you die.
yeah,
The will is for when you die. The rest of this is for before
yeah.
you.
Yeah, so important distinction there too. And I don't know who for the life of me came up with the terms last will and testament and living will and named them such similar names when they do vastly different things. So, but just keeping in mind to clarify there, your will, that's after death. That's where my assets go if they're going through probate. But the living will is, do I want the extraordinary measures to save my life if I'm still here? So yeah, but I think my default recommendation, Vicky, for you or for anyone else, and Vicky, it sounds like in your case, you're already doing this. Work with your attorney. I mean, if you, even without knowing the legal jargon and the right terms to use, just tell them what you want. And then they can make sure the documents themselves are in place. And maybe my one parting words of wisdom, if you want to call them that, on this incapacity planning section of things is, at least in Connecticut, there is no default decision maker. Just because you're married doesn't mean your spouse automatically gets to make decisions for you. So it is so important to have these documents in place. I will say sometimes, I mean, in a medical setting, if this is, an emergency, I'm in a car accident and I'm wheeled into the hospital, my husband's right there with me. Are the doctors going to ignore him and say, we need to see the healthcare directive? Are they going to talk to him? Most likely they'll talk to him. But if you're dealing with banks, if you're trying to do signing deeds and, anything in the financial realm, the banks don't care if you're married. They don't care if you have kids. They say, show us the power of attorney. So again, just really stressing that it is so important to have these documents in place.
So here's the opportunity. You've got an attorney at no cost to ask estate planning questions. And we have only that one question in the chat. So please, people, either before we move on, ask some questions in the chat or open your mic and ask a question. And while we're giving some people a chance for that, there was a couple things I wanted to bring up or make sure that we discuss is that a lot of for these documents to be useful, people have to be able to find them or have them, right? So we'll see is that somebody may usually it's easy with the spouses, they kind of know where all those documents are. But like when my father passed on, I became my mother's power of attorney. So I needed to have those documents. I'm also her medical care agent, right? So I needed to have those documents. And similarly, and we didn't talk about this exactly, but I'm also now the executor for her will. And one of the things that I find as I'm sitting down with farmers that they might be challenged by is to think about who their executor might be. So Allison, if you want to maybe comment on that, or the trustees of a successor trustees of a trust.
Yeah, so on the first point you made, absolutely. Legal documents are great, but they serve absolutely no purpose if nobody can find them or know where they are. So right at the outset, when my clients leave a meeting where we've signed all the documents, I tend to give them multiple originals. Plus, I say I'm going to scan them and email them to you. If you've appointed a kid or a nephew or a niece or whoever that alternate person is or that primary person is, if it's not the spouse, make sure they either have a copy of the document or they know where you keep your originals and can get at them if they need them. Also, to something, Mike, you said earlier, where there's the database, sounds like you can upload your advanced directives. I'm not aware of anything like that here in Connecticut, but I mean, we do a lot of the My Chart system. You have your electronic file with your doctors where you can, send messages and upload documents. So a lot of times I say upload your healthcare directive to there, or if you're a low tech person, next time you go into your doctor's office, give them a copy to make sure they're aware of it. So sharing those documents is important. To the appointment of the executor, trustees, successor trustees, so with the incapacity planning, you need people to step in and help if you're still here and bills need to get paid and, medical decisions made. With the trustee and the executor piece, it's more the after passing. Somebody needs to, if there's documents to be filed with the probate court, who's going to do that? Or the will or the trust says, this asset goes here. Well, there's paperwork that needs to be prepared and signed to make sure that transfer actually happens. Who's in charge of doing those things? So just thinking carefully about who you're appointing in those roles. It can be as simple as I appoint my spouse first, I appoint my son or daughter second, but maybe it's not. Or if you're thinking about that to say that maybe that's just the simplest option, I would say, well, also think about the skill sets of the folks you're appointing. Even if you say I love my kids, but they're not terribly good at paperwork and responding to deadlines and answering emails, so they probably shouldn't be your executor or your trustee. But if you have that person who is, that's really their thing. They're all about deadlines and checklists. And I say that's a good person to be considering appointing in those roles. And to also be thinking about, okay, who's my first choice? But because these documents might be in place for several years, if at some point my first choice isn't able to serve, who's the next person in line? And even if you want to put a third person, there's no kind of limit on these alternates or these successors that you can appoint. But again, always be thinking about the appropriate people to serve in those roles, thinking about how many alternates do you want to have in place. So if this is a simple will that says, when I pass, it all goes outright, or a simple trust, when I die, the trust goes away and all goes to my beneficiaries, one, maybe two alternates is probably fine. If you have younger kids or leaving things for grandkids, or you have these ongoing trusts for beneficiaries that are going to be in place for, another 15, 20 years, you might want to have a lot of alternates in place just because the longevity of that document and the need to have those people in place is going to be around for a while. So just taking those things into consideration.
And the people that you appoint don't necessarily have to be family, right? As long as they're
Correct.
aware that they're and have agreed to be in those positions.
Yeah, and sometimes it's better to not have family, just because maybe the family doesn't get along. So if you're picking one kid over the other, all that's going to do is create more fights and hiring more lawyers. Maybe you don't want to go that route. You want a completely disinterested third person, like an attorney, like an accountant, or somebody else. Or it could just be another family member. Maybe it's a niece or a nephew. Maybe it's a sibling. Maybe it's a close family friend. But yeah, it doesn't have to be family. It can be whoever you think is best suited for the job.
Um, and the similarly, I had worked with a farm. One of the very first farm transfers I had, they had 7 children. Is that they had a family meeting, and this kind of overlaps with the fair versus equal, and there was only one of their children who stayed with the farm and was solely with the farm, and they were trying to figure out how to handle the estate. And one thing that became clear there, that's often clear there, that there was simply, if they were going to do it equally, especially with 7 children, there was no way that the farm was going to be able to financially continue if that farmer had to purchase the interest of their siblings, after death. If they had to buy out their siblings from their shares of the farm, that the farm could not handle that kind of debt load to make those kind of purchases. And sometimes even with 2 children, that can be the case. And so when they listened to all the discussions from all the family members, the parents ended up choosing the daughter who was the one who was all the family meetings, was the most level-headed, was the one who was like, I'm not farming this farm. I don't need this farm. I have my own thing going on. I just want to see the farm continue. And so it wasn't even the son who was going to become who was going to own the land. He already owned the cattle and equipment, but it wasn't even the son that was named the executor. It wasn't the oldest son. It wasn't who was actually one who wanted more of his share. And they just said, "Oh, that's just not what we're trying to do here." Right. And so they picked the daughter to be the executor of their will, who just wasn't going to have a dog in the fight. Who was just really going to carry out their parents' wishes and try to ease the family tensions as much as possible. And maybe you could just say a word about whether trusts continue. You just even kind of mentioned a minute ago about whether trusts continue after the death of someone, or if they continue beyond that. What would their purpose be at that point, and how long do they last after death?
Sure. So with trusts, you can have that kind of ongoing management of inheritance. The most common time we see this is when it is a minor beneficiary. So someone who's not a legal adult, you're leaving an inheritance. I mean, they can't own assets. So instead, if we say, well, yes, it goes to my minor kids, but in trust, and they have to once they turn 25 or 30, that's when they would get it. But until that time, it's held in trust. It's managed for their benefit by someone that I've chosen. But also setting aside just, the simple hypothetical of having it be minor children, these could be grown adults you're leaving inheritance behind to, but for some reason or another, you don't want to just leave it to them outright. One of the most common situations there is one I think I had mentioned earlier, where it's, well, I love my son, but he's married to this woman that marriage isn't going to last, and she's going to try to take him for everything he's worth. So why would I give him the farm or these other assets that are now only going to come up on the chopping block as part of these divorce proceedings? So you could still leave money, say I still leave, the farm, money, assets, whatever it might be, to my son, but in this trust. And I've chosen, my other kid, or maybe I've chosen another, again, friend, family member, somebody else to kind of be in charge of this trust. I've written the rules for when funds are allowed to go out and when they're not. I've written in when the trust terminates. So there may come a point where we no longer need the trust. So it can be age-based, which is pretty common to say that, well, if he's going to get divorced, odds are, that type of stuff happens when, people are going to do wild and crazy things. It's, maybe somewhere between 20s and their 40s. But by the time they get beyond that, they're probably more settled. They're more mature. If bad things were going to happen, they're already done. So maybe the trust is until age 40 or 45. And if if they're over that age, then we don't need this trust. Or the trust is in place till then, and when they hit that age, then it can terminate. Or sometimes with trust too, it can also just be to centralize the management of the assets. We have that, it's the farm, and we have the land, and we have all these other things. And even maybe if we don't have like an LLC or some kind of business entity in place, you can have the trust be the set of rules for how that land and how the farming assets are to be managed. So that way it isn't every single person directly owns a piece and gets a say and could potentially therefore cause problems. It's the trust itself. Maybe that's the owner. So again, that kind of centralized management to resolve disputes and to determine who's making the decisions. This doesn't always work in a farm context, in an actual operating business. But I throw that out there as an option to be, you might have an ongoing trust, not just because it's necessarily a specific beneficiary is too young or too immature or too in precarious of a situation to leave assets to. It might just be for simplicity's sake, rather than having multiple owners of a certain asset, maybe you just keep it in trust.
And I think that brings up the question or issue. I mean, it's not necessarily all or nothing. People will often at least have what they call a pour over will, which you didn't specifically mention. But sometimes certain things like the real estate may go through a trust, and other assets, may still go through a will, as well as those other ones that are transferred directly that you described earlier, right?
Yep. So we have that pour over will. Whenever we do a revocable trust, that's usually we do that automatically too. I'm sure a lot of other estate planning practitioners do the same, where, again, because the will is just meant to direct assets that are passing through probate kind of where they go. The purpose of the pour over will is to say, well, I've set up this trust, and that's really where my instructions are for how I want all my assets divvied up. So I somehow missed something. There was a bank account that we didn't see that ended up going through probate. There was that piece of real estate we never got around to retitling and making it a jointly owned piece of land, so it ends up going through probate. So that pour over will kind of serve as a safety net to catch anything that might have missed. And the will says the beneficiary of the will is the trust. So the end result is everything still ends up in trust and is still going to be distributed as you had hoped.
And that brings up something that I've heard, other attorneys presenting on this will say is you need to make sure that after you create the trust, that your trust is properly funded, or you fund your trust. And that confuses people because they think you must be putting money into it, when in fact what they're meaning is that you're titling everything to the trust, and that becomes part of the expense of creating a trust, is that you have to retitle whatever property so that it's not being held by you anymore, it's being held by the trust. Is that correct?
Yes. So the funding is so important. I'm not sure I've used this analogy in this presentation so far, but I always talk about trusts as if they're a bucket, because that's kind of what a trust is a holding place we create. And if you put things in your bucket, then they avoid probate. They're going to get distributed in accordance with the rules you've put on that bucket. But if you set up your bucket and don't put anything in it, it really hasn't provided you any benefit. So you do actually have to proactively fund the trust, transfer ownership of assets to the trust to make sure the plan is really being implemented. And it can take the form of signing a deed and actually transferring the direct ownership of the real estate into the trust, or transferring your LLC in directly so the trust is the owner. Or it can be, I have my IRA, I have my life insurance. I don't name the trust as the owner, but I name the trust as the beneficiary. So when I pass away, that's when it goes into the trust. So it's kind of a different way to fund the trust. So again, some assets we do recommend be titled directly into the trust and fund that trust at the time the trust is created. Real estate probably being the number one example there. But again, there are these other assets like life insurance, investments, or retirement accounts, which maybe it's perfectly fine to leave those in your own name, just so long as the trust is the beneficiary. So they're going to be funding the trust at your death.
I will just bring both of your attentions to the chat because we have two questions. One, I think may be covered a little later
Yeah, I
about
think
like
I
an
think
LLC, and then one about a prenup agreement. So there's like an instance where when a child is in line to take over the farm, they've had their spouse sign a prenuptial agreement. Is that something that works or is something to consider?
So I'll also profess I don't really practice in the area of family law and work a lot with prenups, but my general understanding is, I mean, one, they're good to have. So if you think there's a concern that the kids might get divorced and you don't want the farm divvied up to, this ex-spouse, prenups are definitely helpful. But there are situations where they're not always going to be 100% bulletproof, and it's always kind of a facts and circumstances kind of test. But I think if you have that concern and you really do want the protection, it is really good to have that prenup in place. There are such things as post-nuptial agreements. Same thing to say, if we get divorced, I still forfeit my right to inherit, or you don't get a piece of this, but those are even less kind of enforceable as the prenups. So if you're going to do anything, I would say do the prenup, but consult with a family law attorney to put that together.
a similar question that I got in a private message was, my father, age 82, started dating when my mom passed away last year, and his new girlfriend wants to move in. He's slowly been getting confused in the last few years. I'm worried about him getting taken advantage of. Um, and when we have the farm property with my dad in joint tenancy. So this is the person writing me and a sibling. If he gets married to the new wife, could she end up with the farm?
So if the property is still owned in joint tenancy with survivorship when your dad passes, I mean, that still passes automatically to the surviving co-owners. So so long as that property stays titled the way it is, that should be fine. But the second you're married, most states, at least Connecticut included, has laws that say your spouse has the right to inherit from you, whether you've said you want them to be a beneficiary under your will or not. It's called the spousal elective share. So just because you haven't named them, they might still be entitled to inherit a piece of your assets. But at least in Connecticut, that's limited to the probate assets, which is why the joint tenancy was still protecting that property, because it bypasses that probate process. But if there's anything that's solely in your dad's name, even if he has a will that says, it all goes to my kids, some states also have laws like kind of in addition to the spousal elective share to say that a will is automatically revoked if you get married after the execution of that will, or something along those lines. So it's possible that she might be entitled to some form of inheritance, even if those documents kind of are in place and saying something different.
And I think maybe just adds a little bit more clarity there, because I find a lot of people don't think about how they actually own the land, and that that there is tenants in common, which Allison mentioned earlier, which is particularly here in Vermont, the law even states that's the preferred way to own, which means that anyone can leave their share of the property. Well, you own it together, and you can own it in different proportions. Um, and it can be transferred. Each party can transfer their share to somebody else through their estate. But the joint tenancy that was mentioned in that example, which is often typically called joint tenancy with right of survivorship, you all have to be owning it in equal shares. At least Vermont has to be equal shares. And whoever the last person is alive is the person who ends up with the property. So in that case, the example that person wrote in, they probably set it up that way with that idea is that it would go there. So you're saying in joint tenancy, at least in Connecticut, that would be, since it's going to transfer automatically, that's not going to go through probate, and therefore that next spouse probably couldn't get access to it.
Correct.
And since this is one of the other owners, not the father, trying to figure out his estate plan, how is the other owner, would it make sense for this other owner to consult her own attorney to just get this clarified?
Yeah. So if you have any doubts of, I mean, at least right at the start, is it survivorship or is it tenants in common? Absolutely.
Right.
Consult with an attorney to confirm that. And then I would say maybe, yes, consulting with an attorney, generally speaking, to make sure your interests are protected is a good idea, but just also being mindful of the fact that maybe one concern I might have in your situation is that just because you own property and your dad owns property with you guys as, joint tenants and assuming it's in survivorship. I mean, I own my house jointly with my husband, but there is nothing stopping me from signing a deed saying, but I want to convey now my 50% interest out to my sister or to my kids. So even if you start with joint tenancy, any one of the joint owners can what we call sever that joint tenancy and kind of do as they please with their interest. So maybe in addition to understanding how it's owned, maybe also kind of keeping an eye on things and seeing, is dad, is the new spouse taking dad to the lawyer's office to just sign some paperwork? Who is dad's power of attorney? I mean, keeping an eye on those assets because you just got to be careful.
Yeah, I mean, I think that was actually going to be my next question. Is if this person is getting confused and maybe getting, dementia or something, then that power of attorney could be really critical here, and whoever that is to be able to make decisions. If he really can't be making decisions about about his present care or his estate.
Yep. So that comes back to absolutely that importance of having those, the powers of attorney documents in place. Because if you see dad starting to fail and thinking about signing things, you can step in and really take over a little bit to make sure the assets are safeguarded.
Just looking at the time, Allison, should we move on and we'll get on to some other questions after we can get on to some other questions after you do the other two sections?
Sure. Or maybe there's one in here I see in the chat. I think I'll answer in about 10 seconds. So just to cross that off. So is there a way to make sure things go to your blood only? So yeah, most documents are set up to say if I leave something behind to my kids and they predecease me, it goes to their issue, which means, to my blood descendants. Sometimes you'll see the phrase per stirpes, which means, again, lineal descendants through the bloodline. So there are ways to include provisions like that in your documents.
And I just realized I wanted to ask we've been talking about revocable trust. Can you just say a couple words about irrevocable trust and when you might use that?
I will, and it's actually coming up in the slides.
Okay.
So I'll say I promise that I'm getting there.
All right.
And it's actually coming up in our next section here, which is the asset protection planning piece. So asset protection planning, or kind of protection from long-term care expenses, right up there, the kind of first line in the slide, which I'm sure goes without saying, everybody knows long-term care can be really, really expensive. The average cost for skilled nursing care in Connecticut is roughly $15,000 a month. In Vermont, it's somewhere around $14,000 a month, but I mean, that depends still too also on where you are. Just depending on where certain clients I have within the state of Connecticut, I have some clients who are paying $14,000. I have some clients who are paying $20,000. So that number can fluctuate depending on the level of care that you need or where you're receiving that care. But at the end of the day, it's still, if you need, or if your, spouse or loved one needs round the clock skilled nursing care, it is just really, really expensive. So if we're looking at this to say, well, gosh, if I end up needing this care at some point down the road, I don't want my family to have to sell the farm and to sell the land in order to be able to pay for that care. I want to protect it. How do I go about doing that? Or how do I cover those long-term care expenses to make sure I don't have to do that? So options for how to pay for your long-term care. The very lucky and sometimes very few just pay for that out of pocket. If you have enough funds to pay for your care on your own, then you pay for your care. You get to pick where you go. You get to pick who your caregivers are. It's all up to you because you're paying the bills. Some people also have long-term care insurance, which I'll go into in a little bit more detail in just a moment, which is just an insurance policy that'll pay out for some or all of that long-term care. But if neither one of those first two options works for you in your situation, it may mean a Medicaid application. It may mean applying to the state to have the state step in and cover all your long-term care expenses. But there's a catch with that. And the number one catch is they say really kind of you have to be penniless or pretty close to it first in order to be eligible. But I'll get into more detail on that in a moment. So, long-term care insurance, I am by no means an insurance agent, but just to give you a little bit of information on how these policies work, they vary. So different policies will do different things. Kind of the more standard long-term care policy and a lot of these policies that came out that you may have gotten as an employee benefit, 10, 15, 20 years ago were really straightforward. The life insurance company, the long-term care insurance company is going to pay X amount of dollars for your care every day. So the example I give is your coverage is $350 a day paid for through your insurance company. Anything above and beyond that comes out of pocket, but that's what the policy covers. Maybe up to a maximum benefit. So my policy covers $350 a day, but my max benefit is $250,000. So that's a pretty standard setup for a long-term care insurance policy. Keeping in mind, again, you can get different variations on policies in that some policies will cover just institutionalized care. So they only cover if you go into a skilled nursing facility. Some cover home care. So if you're reading into the fine print of if you have a policy in place or you're looking at purchasing a policy, kind of pay attention to those distinctions. Some of these policies can also have a death benefit. They're known as hybrid policies. Because with the more standard, more traditional long-term care policies, it was kind of like life insurance. I pay into it for years and years and years. And if this, so with the life insurance example, I have a 20-year term policy in place. If I don't die within 20 years, all my premiums are gone. Those just went to the life insurance company. I don't get anything back. So kind of similar with your more traditional standard long-term care insurance policies, you could be paying premiums in for years and years and years, but if you pass away and you never really needed long-term care, those policies are just gone and you really don't get any benefit from them. But with these hybrid policies, there is a death benefit component to those to say that if you never actually make a claim and you never actually need long-term care, or even if you make a claim but you don't max out the benefits under your policy, the kind of remaining balance can pay back out to your named beneficiaries. So there's all different types of things you can include or have kind of part of your policy or not when you're looking at these long-term care insurance policies. But if you're thinking that, wow, how come I've never heard of this, or how come most people I know don't have these policies in place, is just because long-term care insurance can also be very, very expensive. So most people are just priced out of it because they'll run the numbers and they say, by the time I'm looking at this, I'm already 65. Maybe I have some health issues, or just by virtue of my age alone, the cost to implement one of these policies and get any kind of, decent coverage is just going to be cost prohibitive. So a lot of people don't get them for that reason. And the more of these kind of bells and whistles you want to add on to your policy, the more expensive they get. So if you say, well, I don't like $300 a day, I want it to be $400 a day, well, your premium's going to go up. If you want these hybrid policies with a death benefit, those tend to be more expensive because it's guaranteeing that the insurance company is going to have to pay out at some point. So kind of the more of these benefits that you want included in your policy, it means your premiums are going to increase. Also, too, just because your premium may start off at a certain amount, they tend to also increase. So if you start off with a policy that maybe your premium's only, $2,500 a year, next year it goes up, it's $2,700. The next year it's $3,500. I mean, depending on the care industry or the insurance industry, costs go up, and the older you get, those premium increase can be pretty substantial. So even if you can afford your long-term care policy today, at some point you may have to surrender the policy just because you can no longer afford the premium payments, which is another potential reason why sometimes people don't get these policies, is because they know in the long run they're not going to be able to maintain them. But that being said, I don't want to, scare people away from long-term care insurance, because it is potentially an option. And I think the simplest thing to do is talk to an insurance agent, have them run the numbers and say, okay, based off my age, based off of, any health issues I might or might not have, kind of what policies are available to me. So, I mean, do that homework, but just go into it knowing that depending on how much money you have to allocate towards these premiums, it may not be an option. So if you can't afford to pay out of pocket, you're not able to afford long-term care insurance, that leaves us with Medicaid. And even though Medicaid is a very large program, it does a lot of different things. What I'm focusing on today is specifically that portion of Medicaid that deals with long-term care. So if you need to go into a skilled nursing facility and again, don't have the funds to pay for it yourself, the state will step in through the Medicaid program and cover all of your long-term care expenses. But as I mentioned before, the number one eligibility requirement for Medicaid is you have to have pretty much spent down all your assets first before the state is going to be willing to step in. And even though Medicaid is a federal program, but it's run by the states, so each state has slightly different eligibility rules for their Medicaid programs. So in Connecticut, that, I said you have to be penniless. It's not actually zero. In Connecticut, they graciously say you can have $1,600 to your name, but anything else above and beyond that needs to be spent down in order for you to become Medicaid eligible. In Vermont, it's a little bit higher. It's a $2,000 spend down threshold, but you have to get below those before you're going to be deemed financially eligible. Also, keeping in mind, if you're married and only one spouse needs the care, that doesn't mean the non-applicant spouse, or sometimes what we call the community spouse, is fully protected. There's probably also going to be some spend down on the spouse's side as well, just because the government looks at married couples as a joint financial unit. They say you're married, you have the financial and moral responsibility to pay for your spouse. So even if I don't need the care and my husband does, I may still have to spend down some of my assets. So kind of to give you a little bit more specifics in terms of, well, what does that look like? So in Connecticut, and I'll continue to use the example, if my husband is the applicant, he's the one that's applying for Medicaid, he can only have $1,600 in his name. And then for me, I get to keep either 50% of the marital assets or up to a maximum of about $162,000, whichever is less. So we have to run the math. What assets do we have as a combined married couple? And depending on the numbers, I can keep 50% of it, or I can keep $162,000. That's the ultimate ceiling. Best case scenario, that's the most I could ever possibly keep. And everything above and beyond that would need to be spent down. So I've had certain clients come to me that say, well, okay, my husband's applying for Medicaid, and sure, he has, maybe some life insurance, some bank accounts, but I have my own retirement account that has $300,000 or $400,000 in it. And I say, well, unfortunately, I mean, maybe there's some things we can do to try to protect the assets, but if we don't really get into the details for simple purposes of a hypothetical for our discussion today, it's really, I have to tell them, you got to cash in the IRA, or at least a chunk of it, and spend it down, because otherwise your husband's not going to be deemed to be eligible, because collectively as a married couple, you have too much money. There's also a minimum though. So there's that ceiling. So the absolute maximum amount the spouse can keep is roughly $162,000, at least in Connecticut. Vermont's the same. They also go by that $162,000 number, but there's also a floor. So the government says if you only have, like $20,000, then we're not going to apply the 50%, you still have to spend down to 50% of the marital assets, because there's an absolute minimum amount of assets we want you to have too. So in Connecticut, that floor is $50,000. So if the combined marital assets is below $50,000, then there is no spend down, because again, they say that they absolutely want you to keep some amount of money. I looked into Vermont. I think their floor is roughly $32,000. So again, it varies from state to state. But I think the big takeaway here is just simply that even if you're married and only one of you is applying to Medicaid, that doesn't mean we can just put all the assets into this non-applicant spouse's name and have it be protected, because that just doesn't work. And one other comment too is that even though I said Medicaid, I'm talking a lot about skilled nursing care and kind of institutionalized care, sometimes we call it. Certain states have Medicaid home care programs. So in Connecticut, if you need 24/7 round-the-clock care, but you're able to get that care in your home through caregivers, we can still apply to Medicaid to pay for that. So just because we say Medicaid doesn't automatically mean skilled nursing care. That tends to be more common just because a lot of people can't necessarily be able to coordinate the care somebody needs in their home, but it's a possibility.
We do have a question, Allison, that I have.
Sure.
And the question is, I'm going to try to use the right language. What are your thoughts on creating a bequest that's tied to an overall value of an estate? For example, if the value of the estate is above $1 million, you bequest a certain amount, like 100,000.
Okay, so going back to kind of the wills and the trust, who gets what.
Yeah, tell you what, I don't want to break up the continuity of this Medicaid part, so let's save that question for the end and just focus in on Medicaid.
Okay, so whoever asked the question, I promise I'll address that at the end. All right. So for the Medicaid eligibility piece of it, again, Medicaid eligibility requirements are very complex. I'm going to try to hit the high points here. But I mean, it's still, if you have concerns about long-term care asset protection, my default is still you should be talking with an elder law attorney in the state that you're living in to really get into those details. But Mike, you hinted at before that a lot of times the house is protected from this Medicaid spend down. And the requirement is that you or your spouse, as long as one of you is living in that house, that's how it's protected. So even though there's that $1,600 requirement or $2,000 spend down requirement, and the spouse can only keep X amount of dollars, we take the house totally out of that equation. So long as one of you is living there, it's protected. There's also certain other exceptions where they say the house is protected if you have a disabled or minor child, something like that living with you. That can be an exception. There's also some other very specific exceptions. So it's not that you or your spouse living there is the only time the house can be saved, but that's the most common one. Also too, and Mike, you had also mentioned this, the house is protected plus contiguous parcels are kind of included and encompassed as kind of the house or the home property. So if you have the house and then you have an abutting lot that's contiguous, we can probably protect both of those under that umbrella of so long as you or your spouse is living at the house, it's protected. But being aware that there are equity limits. So in Connecticut, if we're trying to protect the house and we're trying to protect, again, which includes any contiguous lots, the maximum amount of equity that we have in those properties can't exceed, again, roughly about $1.1 million. So if the total value of the land is 1.5, we just don't get to protect everything because there's still that ceiling for equity. And in Vermont, it's lower. It's around 252,000. So
752. You said two.
Oh, I'm sorry. Yeah, 752.
Yeah.
So again, very state-specific rules varies, but just to point out that even if you hadn't gone to a lawyer and you hadn't done some asset protection planning, which I'm going to talk about what some of those strategies might be in a little bit, you can pretty much guarantee the house is going to be protected so long as either you or your spouse is living there. But that protection doesn't necessarily last forever, which is why it's not always just an ideal planning technique to say, oh, okay, well, one of us is always going to be living in the house, so it's protected. Because there's always those unforeseen circumstances where initially, yes, it was my husband that needed Medicaid, but then out of the blue, I was in a car accident, I passed away, and I was the one that was living in the house. So even though my husband's on Medicaid and the house initially, when we applied for him, the house was deemed a non-countable asset. Now I've passed away, I'm not living there. All of a sudden, that house is a countable asset. So if there ever comes a time where either you or your spouse aren't living in that house anymore, and I know I gave an extreme example of me passing away, but maybe it's my spouse needed care, and then a couple of years later, I all of a sudden needed care. So now we're both in skilled nursing, and now that's why nobody's living in the house. Again, it comes back to we're not living there, so now the house isn't protected. Also, too, even if, and I'm going to keep picking on my husband, my husband's the one that needed the care. We got him eligible for Medicaid. The house was a non-countable asset. I lived in the house for the rest of my days, but the state is still waiting in the wings to say, we spent all this money on your husband's care. We'd really like to get repaid for that, because that care is expensive. So what they can do is they can place a lien on your assets, your probate assets after you pass away. So let's just say my husband needed care, so we titled the house in my name. He passed away. We didn't have to pay anything back to the state, but they had put this lien on the house, but I still lived there. And so they don't really enforce that so long as I'm still living. But then when I pass, that's when the state can potentially come in and enforce that lien. So again, just kind of coming back to the one kind of statement I made earlier, yes, as long as one or both of you or your spouse are living in the house, it can be protected. But that protection doesn't necessarily last forever, because one of you can stop living in there can come a point where neither of you are living in the house, or it can be after the death of both of you to pass. The state has these recovery rights and can potentially come after your estate, which might include the land.
And I think that just brings back up what I was saying earlier about I guess actually maybe your next point is that if the house is not a part of the probate estate, there is no recovery, right? And so what I was saying earlier about the enhanced life estate as well here in Vermont, that makes it a non-probatable asset, which is why a lot of farms will use it or a trust.
Yep. So that's why state, at least the way it works in Connecticut, and I think it's the same in Vermont, the state's recovery rights extend to the probate estate. So if there's nothing in the probate estate because everything's passing through joint ownership or beneficiary designations, that's potentially a way to protect the assets. But again, you got to be mindful of how those assets are owned.
I know that most of my work is here in Vermont, that just working throughout New England, that a lot of that Massachusetts and Maine are states that particularly are vigorous about estate recovery post Medicaid. So particularly anybody out in Massachusetts and Maine, you really need to keep that in mind.
Yeah, and I would think Connecticut falls somewhere in the middle. They're not always coming after estates, but it's not uncommon for them to do. So I wouldn't say they're necessarily zealous, but they're not falling asleep on the job either. So, but yeah, just being very mindful of what the recovery rights look like in your state in terms of what the state is allowed to go after, and how active they are in pursuing those recovery rights is important to know.
I wanted to just stay on the house value again for a moment. So if you've got as I was mentioning earlier, that if you have a property that where your home is and you've got these contiguous lots, right? So that as long as they're below that 752, that that those lots are considered, but the ones that are further away are not. And I just want to remind people about that. In this context, this is where it would come in. Any of those lots that are not contiguous are going to be they're still going to be considered as an asset when it comes to your Medicaid eligibility. And what we've seen sometimes is even if they're contiguous lots, but they're separate, what the attorneys here will do is actually do a lot line adjustment, merge the lots so that they are, even if they're separate lots that are contiguous, they want to make it one lot. So it's very explicitly clear that that is the one, all that land for the farm goes with that residence. But you do have to watch if you get above that, if that's going to put the property value above 752. So in that, can you just clarify what happens when you get above that number? Because you're still have that eligibility up to that point, right? But then they still ding you for what you're over.
Yeah, so the overage becomes part of the countable assets that are now subject to that Medicaid spend down. So you have to some way sell off a portion of the land or find a way to kind of reduce the value of the land to get back below those eligibility thresholds at 752, or else the state's just going to say, well, then you're not eligible for Medicaid, so we're not paying for your care.
Okay.
All right. So Medicaid spend down, I mean, it's pretty grim. No one likes to talk about it because the end result is the rules aren't great. You got to really spend down all the assets to get below these eligibility thresholds. But there are certain tools we have in our toolbox to protect assets so they don't have to be spent down. And I mean, there's a bunch of things we can do, but I'm going to focus on a few strategies today. primarily gifting. If you have the foresight to say, I think I might need long-term care at some point in the future, or even if I'm not totally sure I will, but on the off chance I do, I just want to make sure the farm, the land, the business is protected. You can give away the assets. And that way, if you then need a Medicaid application at some point down the road, I know it's a kind of a tongue-in-cheek statement here. When the state says spend down all your stuff, you can say, well, I don't own that stuff, so now it's not subject to the Medicaid spend down. So, but with gifting, so let's just say I know I might need long-term care at some point. I'm just going to give the land, I'm going to give the farm to the kids today. That in and of itself doesn't automatically protect those assets, because with every state that I'm aware of in terms of Medicaid eligibility, there's always a look back period. In both Connecticut and Vermont, it's a 5-year look back, which means even if I was submitting a Medicaid application for my husband today to say, I know today he's below $1,600, I want you, the state of Connecticut, to pay for his care, they're going to say, well, that's great, but give us 5 years worth of all of your bank statements, 5 years worth of quarterly statements for your IRAs, copies of deeds, titles to cars. They do a forensic accounting to then see in the 5 years leading up to that Medicaid application, what happened to your money? How did you spend it? And if they find out that you gave assets away during that 5-year period, they ding you and they either say, you're not eligible, or at the very least, you're not eligible for Medicaid benefits for a period of time. So in my example of, okay, I'm going to give my land and my farm to the kids today, we have to now cross our fingers and hope that I don't need a Medicaid application for the next 5 years. And if I don't, and we get beyond that 5 years and I never needed to apply, perfect. Now those assets are fully protected. But if I need a Medicaid application within those 5 years, now I'm not going to be eligible for Medicaid. So what it means is that probably we need to undo that transfer, or what we call cure the gift. I need to get the land and the farm back, otherwise, and then find a way to sell it, or otherwise spend down my assets to get me below the eligibility threshold for Medicaid. So gifting can be a strategy, and I'm going to talk about that in a little bit more in my next slide, where I get into how do we gift? Is it an outright gift? Do we use an irrevocable trust? But also, just the final point on this slide is that you can also sell assets. If you sell an asset for its full fair market value, it can be the day before you're applying for a Medicaid application, and there is no look back period, because the state says so long as you sell your assets for what they're worth, they don't take an issue with it. They also say you can spend your assets. You can even spend them foolishly, but so long as you spend your money on yourself, that doesn't trigger the 5-year look back, and it's fine, and you'll be eligible for Medicaid.
But if you're selling it, then that's that cash that you just got for selling it that makes you potentially ineligible, right? That has to be spent on the nursing care first and depleted, right?
Yeah. So my example where I say you could sell something today and apply for Medicaid tomorrow, I mean, in theory, yes, but I sell my land for let's just say I have a parcel I sell for $250,000. Now all of a sudden I have $250,000 more of cash that needs to be spent down to get me eligible.
Right.
So this is where I want to get more into the irrevocable trusts. So with gifting, in my original example, I can give my kids directly the land, the farm. I can just sign the documents and say, you guys own it today. But if I am concerned about some of these kind of what ifs that I had talked about in the estate planning context, what if my kids are really not great with managing money? What if they're in a relationship where they're likely to get a divorce and the ex-spouse is going to try to take their assets? What if there's these reasons that for some reason or another, I don't feel comfortable putting my beneficiary, the person I'm transferring this to, I don't feel comfortable putting it directly in their name. Because I mean, that's option number one when it comes to gifting, because it's simple. But if you say that doesn't really make sense for me, one of the things we can also do is gifting, but to an irrevocable trust. So we've talked about revocable trusts in the estate planning context. And just to clarify a few things, with a revocable trust, I mean, you are a trustee, you are the beneficiary, it's all you. You can rewrite the rules of that trust, you can take assets out, you can put assets in, you really still have total control of the assets. And it's because it's not a revocable trust, isn't there to separate you from control, it's just there to make sure the assets don't have to go through probate. With the irrevocable trust, you are not the trustee, you are likely not the beneficiary. We really have to cut ties, the ties you have with this asset, to get the protection that we're seeking. So in this example, instead of maybe saying, I'm just going to deed the assets or gift the assets directly to my kids, I'm instead going to transfer those assets to the irrevocable trust. And maybe my kids are the trustees, probably my kids are the beneficiaries, and the trust says, when I pass away, the trust is going to be allowed to terminate, and then it can go outright to them, because at that point, I'm not concerned about long-term care or my kind of creditor, so to speak, because I've passed away. But what it means is that the trust itself is the owner of those assets. So if my concern was my kid is going to get divorced and their spouse is going to take everything, well, even if that happens, and even if my kid is the trustee and the beneficiary, the trust itself is still deemed the owner, so it's protected, not only from my long-term care expenses, but from my beneficiaries' potential creditors. The downside to doing this is irrevocable trusts are, again, kind of irrevocable. You get one shot at writing the rules for that trust, and you don't ever get to rewrite it again. Once the assets go in, you don't get to take them back out. I mean, possibly there's a way to undo it if need be, but it's difficult. And so because the intent is we don't want you to get the assets back, because if we get them back to you, now they're still subject to that Medicaid spend down. It can also be fairly expensive from a legal standpoint to set up a trust like this. So it's more expensive to do an irrevocable trust than it is to do, I just sign a deed saying I give Johnny the house and I give him the farm. So there are benefits to doing an irrevocable trust. The number one being that it gives you more protection. But the downside is that it's pretty inflexible. So if you're considering an irrevocable trust, you really have to think long and hard about, is this really what I want? Am I really comfortable with this? And to some extent, I mean, that really applies to all of this entire gifting question. I mean, do I gift it directly to the kids? Do I gift it to an irrevocable trust? The end result is you've given away your assets. So first, you really need to consider, am I comfortable with that loss of control? And if the answer is no, then I would say, then you're not ready to do asset protection planning. But when you get to the point where you say, yes, I am now comfortable parting with that control over that asset, now we can get into specifically, do I trust the person I'm giving it to and I can give it to them directly, or would I feel more comfortable putting some protections around it, which would mean maybe instead I'm gifting to the irrevocable trust. But also still keeping in mind, whether I do an outright gift, whether I gift to an irrevocable trust, the 5-year look back remains the same. The state says either way you slice it, that's a gift. So you still got to get more than 5 years from the date of that gift before you're going to be Medicaid eligible.
So,
All right. So
are there any, I definitely want to make sure we get this last half an hour for the business entities. But are there any quick questions on the Medicaid asset protection?
oh, sorry, and I keep skipping my slides here.
Yeah. All right. I'm not seeing any new questions in the chat. And then,
Mike,
yes, Rob.
the contiguous lots, we don't live on the farm. We live away from the farm about 1.5 miles away. We own the house next door to us as well. And they're contiguous lots, but they're two separate titles. If we need Medicare, can we consider these two residential places contiguous lots?
Well, I think the problem is going to be that it's only one residence. Is that right, Allison?
Yeah, so it comes down to it's one residence. And when we're talking about contiguous lots, it tends to be, it's the farmland, it's the vacant land, because it still all has to fall under that umbrella of this is my primary residence.
Okay,
Right.
this is two separate houses.
Right. And I think that was a question I was going to try to ask a little earlier was if you have a farm and you have multiple houses there on a contiguous lot, they would probably want that value of that second house that's on the property that has to be in addition, right? Or it won't be a part of the exclusion, right? Because it's only one house you get to claim, right?
Exactly.
Yeah.
Okay, thank you.
We do have another question that I got, which I'm gonna try to my best to frame. Is this when we're talking about the Medicaid paid long-term healthcare, is this like a trading? Are they trading free Medicaid long-term care for that step-up cost basis benefit?
So I don't think the two are related. Medicaid is simply, I need care, I can't pay for it. The state will come in and pay for it. So I mean, by the time you pass away, if you're on Medicaid, you don't have any assets, or best case, you have $1,600 or $2,000, and then you've already spent down everything else you own. That step up basis piece of it is a tax component of inheritance. If I pass away and I bought my house for $100,000, and at the time I pass away, it's worth $500,000, and it passes to my kids, their tax basis in the house gets stepped up and becomes the fair market value as the date I passed away. So it's kind of two separate areas. One, the step up basis is for inheritance, and Medicaid is while I'm still here, how do I get my care paid for?
Well, and I think the other part of that is if someone is gifting, right? So then you're gifting that the basis, right? So if you're trying to get it out of your name and you gift it to your heirs, and so they're getting a gifted, well, they're not your at that point, they're not your heirs, but you're gifting it to somebody, and they're going to get your gifted basis. They will not get the stepped up basis.
Oh, gotcha. Okay. So then I would say with that, it depends on how you set up the transfer. So if I do, and I'll use real estate. So if I give my house to my kids and I just sign a deed to say it goes to Johnny, he owns the house, then it is carryover basis. So if I bought my house for $100,000, even though it's worth $500,000 now, Johnny's basis, my son's basis stays my basis. He carries over whatever I've had. But so because the stepped up basis only applies at death, at my death, so it applies to inherited assets. But there's a way to include kind of or have a retention of me to have a small piece of ownership interest in the property that's not going to cause eligibility requirements for Medicaid, but still allows my person who I've transferred the property to get that stepped up basis when I've passed away. And it's called a life use or a life estate. So same thing, I sign a deed that says I deed the property to Johnny, but I retain a life estate for myself. And what that life estate is my legal right to continue to live in the house for the rest of my days. It also makes me legally responsible to still pay the carrying costs. So I still have to pay the taxes and the insurance and the utilities. But then when I pass away, from a legal perspective, my life estate kind of vanishes. And now Johnny solely owns the house in his own name. And because I retained that small portion of an ownership interest, Johnny still gets the stepped up basis. So I think in terms of whether you get that step up, it all depends on how you're setting up that transfer.
All right, I think we need to move on to business entities. So we can cover that in the last section here.
Okay. So using business entities is highly recommended, as I'm sure comes as no surprise. It's the number one reason why you're going to want it in place is liability protection. If I own my farm directly in my name and I have an employee who hurts themselves, trips over in a pothole and breaks their ankle, or somebody who comes onto the property gets injured, and I'm the landowner, they can sue me directly as the landowner. And now, guess what? What's also in my name? It's my bank accounts, it's my life insurance, it's my retirement accounts. So they can come after whatever I own directly in my own name. So as a way to protect that, if the land or the business is instead owned in an entity, and same as example, somebody comes onto the property, but it's and gets hurt, but my LLC owns the land. The landowner is now the LLC. So they can sue the LLC and come after what's in the LLC, but that's now separated from my personal assets. So they can't come after my bank accounts and my life insurance, but they can come after the land or the business, whatever's in that entity. So it limits the liability. You may also want to do multiple entities, and that's actually a fairly common setup for us, where we say the land should be owned in one entity and the operating farm business itself should be in a separate entity, because that further limits your liability. Because maybe so in that instance where somebody comes onto the land and breaks their ankle and tries to sue me, they can come after the land, but the operating business is now even segregated out from that, so it's further protection. So using the business entities can also help when we're talking about doing these transfers in terms of how do I actually now start transferring an ownership interest into or over to my kids or whoever the heirs are there, or my successors are that are going to be taking over this business interest. When it's a corporation, when it's an LLC, and I'll probably stick with an LLC as the example because that's the most common entity that we tend to see, just because they're easier to work with than corporations from a legal and a tax perspective. I can just, rather than trying to figure out, okay, I'm going to give Johnny like maybe a portion of this, portion of that. I own the LLC, and you know what? I'm gifting Johnny 10% of the LLC this year. I'm giving him another 10% next year. It can facilitate that transfer. I find this is particularly helpful in regards to real estate because if I own the land directly and I'm trying to transfer a piece to my son, okay, this year I give him, depending on how much I want to give him, I give him a 1/10 interest in the property. Next year I sign another deed, he gets a 1/10 interest. The year after that, he gets another 1/10 interest. Well, was that a 1/10 interest so I made that 1/10 interest in the first year, so that is a 1/10. And next year, when I do another 1/10, is that a 1/10 of my 90% that I still had, or was that still a 1/10 in the whole of the parcel? It can get confusing as to who owns what and trying to track down multiple deeds over multiple years. So again, having all of the land or all of the business entity owned in the entity itself and just transferring percentages of the entity can make those transfers a whole lot simpler and easier to track and to value. So how do we go about actually making these transfers? One of them is if we are doing this not only from an asset protection standpoint, let's just say my daughter's been working on the farm for years and years. I just want to give her a piece of the farm in recognition of all the work she's put in. You can just transfer that. So whether it's the land or whether the business, you can just make an outright gift. And maybe it's just, hey, I'm ready to retire. Here, you get it. Or maybe it's kind of, as I hinted at before, we'll transition a piece over this year, a piece over next year, a piece, over time, until ultimately over several years, the full value or the full amount of the entity has been transferred. You can do that. That can be helpful specifically if you have concerns about whether you need to file a gift tax return or not. So because with the federal gift tax, I'm not sure how many people are familiar with the term of annual exclusion gifting.
We had an accountant on last week who was talking about this.
So everybody knows that. So you're allowed to give up to $19,000 per year per recipient. So if you want to say, I just want to avoid the need to file gift tax returns and all that complication. So I'm just going to gift, a portion of the business worth $19,000 each year. You can break it up. So again, you're doing those gifts over time, that annual exclusion gifting. So it bypasses the need to have to file federal or state gift tax returns.
And that's for both parties, right? Because that was a clarity question for last time. So the receiver doesn't have to file anything and the giver doesn't have to file anything?
Only the giver of the gift would be, if anyone had to file anything, it would only be the giver of the gift. But if the giver is gifting below 19,000, then nobody needs to file anything. But I'm not aware of any gift tax rules that allow or require a recipient to file. It's always the donor of the gift. So transferring over time can be good, but it may not, or just gifting in general may not work for you if it's, well, okay, yeah, I want to gift the farm to the kids, but how am I going to fund my retirement and pay my bills? Maybe I can't afford to gift it. Maybe it really does need to be some kind of sale so I can get some money back. Or if we're looking at this now from an asset protection standpoint, if I gift the farm to my kids and I need a Medicaid application in 3 years, now we've just caused a huge problem for my Medicaid eligibility. So you got to kind of take all these things into account when figuring out, is gifting going to be the strategy that works for us? And maybe this leads us down to the second option where we make it compensation based. So, my daughter's been working on the farm for 15 years. So we set it up going forward now that every year in terms of paying her salary, maybe it isn't just here's a check and here's what you earned. Maybe it's you're getting a portion of the business as part of your compensation. Also, too, you can go into a straight sale of the property to say that, yep, transferring it to son, daughter, the person who's taking over the farm, and just make it a normal arm's length transaction. I'm selling this to you. And as part of that, it can be really difficult to go out for the purchaser to go to a bank and get a mortgage and get the funds to purchase the land and to purchase the business. So what you can do instead is, okay, I'm selling the land to my successor, but I'm the bank. So it's seller financing. So I sell it to them. I take back the note. They are paying me over time. So that can make it easier for them to process if it's too difficult or maybe just not feasible for them to get more kind of institutionalized financing. Also too, rather than you're not making them pay, 100% of the purchase price as of the date of the transfer and say, I recognize it's going to take time for the farm to generate sufficient money for you to pay me back. So you know what, it's a 10-year note or it's a 15-year note, or here's how much you're going to be paying me every year. And you can set those terms to actually facilitate making that transfer easier for the purchaser, to take over the farm.
Allison, if I could clarify a couple of things. So if you want to set up an LLC and you're going to do a gradual transfer where you're going to be a partner with that next generation, then if you're going to do a financing scenario to sell your shares in the business to the other portion over time, so you're not going to sell out completely, then really the seller financing is really the only option, because otherwise no one can get a loan to buy LLC shares. It would have to be the entire LLC by having a loan. And so then you're on the hook for for that loan to buy yourself out. And so it creates this kind of odd circle. So we don't usually see that. It's usually a seller financing if it's not a gift or a cash purchase where family member might buy a certain number of shares every year. Or it might be the sweat equity based compensation every year. But when it comes to the financing, it's either the whole LLC is borrowing the money, or if it's just to buy a certain amount of shares, the financing has to be that seller financing.
All right. So also too, with business entities, once they're set up, it's very important to have the governing documents in place in terms of how these entities are actually going to be run, not only from a day-to-day, but if something happens down the road and somebody needs to sell their shares or somebody passes away or just can't work anymore, it kind of you write all the rules for what happens, for how the business is to be run and how it's to operate and function if and when certain people need to transfer their shares. So the first section of my slides focuses on the actual operation, the day-to-day of the business. How is it run? And again, because I'm focusing on LLCs, the governing document with an LLC is an operating agreement. And in that operating agreement, you appoint a manager. Who's the person that's actually handling the day-to-day decisions, making purchases, signing lease agreements, kind of those everyday running the business decisions. Is it one person? Is it two people working together? Or you can say, well, right now it's me, but if it can't be me at some point, then it does become this person next. And also just a point here, I've done transfers where we've transferred actual ownership of the farm to kind of the next generation, but me being the person who kind of started the farm, was running it, I can still be a manager even if I'm not an owner of the LLC itself. So that's sometimes a way where, again, if it's that situation where I still need some income to fund my retirement, but I'm really still looking to transfer the ownership and more running of the day-to-day, or some of those responsibilities over to the next generation, I can still stay on as a manager and get some compensation for that. So maybe just keeping that in mind.
In that case, they're an employee rather than an owner, right? So
exactly. Also too, and I think I kind of covered this a little bit, but just to clarify, so the operating agreement will state who that manager is, and again, potentially successor managers if the originally appointed manager can no longer serve in that role. It's also going to clarify the powers of the manager. So what things is the manager allowed to do on their own? Or are there certain things where we don't want the manager to do on their own and they really do need the consent of the other members before taking action? So again, things I kind of mentioned before, regular or minor purchases, opening bank accounts, signing documents, kind of more of those everyday day-to-day tends to be the powers that we say, yes, we trust the manager to kind of handle those in their sole discretion. But larger decisions will require the consent of the other owners of the LLC or the other members. So if you're going to sell some or all of the assets of the LLC, yeah, we need the members to weigh in on that. If you're going to enter into a really big financing, I'm going to get out $100,000, $200,000 mortgage onto the property, I would need the other, or basically transactions of over a certain dollar amount. I need the other members to consent to that. If I'm going to do away with the business and dissolve it completely, I need the other members to consent with that. So there's some powers that you can say it's okay for just the manager, but then delineate, but maybe there's some things we want all of the owners to have to weigh in on before it can be done.
I think it's important to clarify what you're describing as a manager managed LLC, but there can be member managed LLCs where there's not just where there's not a specific manager, and decisions are going to be based again on how things are designated in this operating agreement, or by a vote of which is often by a vote of the members, either a straight up vote or a vote that's proportional to ownership shares, depending on what the issue might be.
And I'm so glad you mentioned that, Mike, because it segues perfectly into my next slide, which are these voting rights. So particularly if this is a member managed LLC and there isn't one sole manager making those decisions, the operating agreement will clarify what those voting rights are. So do I have kind of, if everybody has, if it's me and my husband and my two kids and we all have a 1/4 interest, do we each have an equal 1/4 share, or is it weighted differently? So is my vote based off of my actual percentage ownership in the company, or is it weighted differently depending on kind of what role I'm serving? Also, too, which decisions require what percentage of the vote. So maybe there's decisions that we say, hey, as long as we have a simple majority, as long as it's over 50%, we're good. But maybe for some of those bigger decisions, like, are we selling all or most of the assets of the business? Are we dissolving it? Maybe that requires a super majority of like 75%, or maybe it even requires unanimous consent. So it allows you to think through all those options and put all those rules into place. Because if we get to the point where these are the issues that are coming up and we don't already have an operating agreement in place, I mean, and Mike, you can probably speak better to this than I can. I mean, it can get terribly messy without any structure, without any guidelines. It's kind of a free-for-all in terms of what's actually going to happen. So having these rules in place in advance can be extraordinarily helpful. So also with the operating agreements, and kind of maybe this is getting more into the buy-sell agreement piece of it, which can be encompassed within the operating agreement. It can be a separate agreement, but generally speaking, it's the rules for somebody needs to part with their ownership interest for some reason or another. You get to set the rules for what happens to their ownership interest, and a lot of times there's a division between they're trying to transfer during their lifetime for some reason or another, or is this a transfer because they've passed away and they just owned, still had ownership interest of that entity at the time they passed. So if it's during lifetime, this is maybe I'm being forced to sell my ownership interest because I'm going into bankruptcy, I'm getting divorced, I have creditor issues, and I'm being judicially forced to sell my ownership interest. Maybe I'm just retiring and I want out. I've become disabled. I'm not able to work on the farm. So it's in the best interest of everybody for me to part with my ownership interest because I'm not really involved in the farm anymore. Or there's just a disagreement where the parties can't get along and somebody needs to get out. Kind of all these things can be reasons for wanting or needing to transfer your ownership interest during your lifetime. And then, of course, obviously upon death, that's simple enough. I passed away. Kind of what is going to be allowed to happen with my ownership asset or ownership interest upon my passing. So one of the most common provisions we tend to see in these buy-sell or kind of buy-sell agreements or transferability restriction sections is that you can dictate that, okay, if I have to sell my ownership interest, let's say during my lifetime for one reason or another, or I want to sell my ownership interest, that I first have to offer it to sale for purchase to the other existing members of the LLC. Or even if none of the members want to purchase, I have to offer it to be redeemed by the business itself can buy them back from me, which may leave everybody else who's going to be continuing to remain in the business kind of better off, because now you're not going to be saddled with some outside third party that's going to come in with an ownership interest. You have the option to kind of keep that within the ranks and purchase that back. You also get to set the purchase price to say, it's not uncommon too, particularly with these lifetime transfers, depending on the reasoning why, you can kind of disincentivize people for trying to sell during their lifetime because they say, okay, you want out, I get to buy back your interest. And guess what? I get to buy it back at a 50% discount. So it kind of maybe prevents people from looking at this as a cash grab to say, well, and if that's what you want to do, I'm only going to pay you half of what it's worth. And even I can dictate how I'm going to pay that back. It's not necessarily like you're going to get, 100% of the proceeds as of the day we make that transfer. Maybe it's I get to pay you under a 20-year promissory note. So again, we try to tend to make it easier for the existing members or the company to be able to purchase back that interest if they need to. So hopefully it doesn't impact the viability of the farm. Also too, with we got to also value how that interest, if we're determining a purchase price for that interest. I mean, yes, we can say it can be discounted by 50%, but first of all, we have to establish a value for it. So how do we determine that value? A really formal way to do it, this is not necessarily a recommended way, but I mean, you can get an appraisal. So if it's the business, if it's the land, we can hire appraisers. Sometimes we say maybe it's actually we want to get 2 appraisals and we average out the 2 to kind of make it fair. That's always an option, but that can be a pretty expensive option. So maybe we're just doing it based off of the balance sheet. So the business's balance sheet. If I'm selling my farm interest, let's see, look at the actual farm and what it's worth and what it's bringing in. And if you're using the balance sheet approach, you really got to keep updated figures and updated records, because if this is something where now we're looking at a purchase of a portion of the ownership interest of the entity, and your books are 2 or 3 years out of date, it is so hard to then kind of come back and kind of recreate those numbers to determine the value of the business. For interest being transferred at death, maybe it's a little simpler, or maybe it's really similar to the lifetime transfers where you still can say, when I pass away, it still has to be offered back to the other members or to the LLC itself to purchase. But maybe we say, well, maybe it's okay when I pass away to allow my membership interest to pass in accordance with my will and my trust, so long as it's passing to a kind of a permitted group of recipients. Because maybe my beneficiaries is already people who are already owners, or maybe we say it's okay, or part of that permitted group of recipients is lineal descendants. Let's keep it in the bloodlines. So kind of think about that. Maybe we say, yes, it's okay to pass under the will. Maybe it's not. If it's not, we do want to mandate that it be offered for sale to the other members or to the business. Kind of same provisions. We can dictate purchase price. We can dictate how we value the business, all those same things. But also too, specifically for when someone passes away, we can have the members of the LLC or maybe the LLC itself own life insurance policies on the members, which can help fund the purchase of those ownership interests too. Because I mean, it's all well and good to say, okay, I'm going to offer this, to ownership interest to sale to the other members. But if nobody has the money to buy it, it's still not a good situation. So life insurance can be immensely helpful in that regard.
I'll just tell you a couple of things that what I see is that in the buy-sell agreement for non-real estate assets, so the entity maybe holds livestock and equipment, and not real estate. The buy-sell say it'll be a 10-year purchase. Time for that they have 10 years to make the purchase, financed over 10 years at the it'll designate in the operating agreement at the FSA interest rate at the time that they're making the transfer. And then with non-members that are heirs to somebody's interest, they often come in as what's called disassociated members, where they have no management control whatsoever. They only have a financial interest, and they can request for the buy-sell agreement to buy them out. And that's particularly an example of where that life insurance becomes really important, to be able to buy out those heirs that are not a part of the farm, because you don't want them to be a part of the farm. And you'd also maybe not have to be in the position to do the financing. But the life insurance can be really a useful tool in addition to just structuring the buy-sell agreement in a way that the farm is going to be able to afford to make a purchase.
All right, and just in interest of time, I'll get through my last couple of slides quickly here. So don't just rely on boilerplate documents, something you got off Google, somebody else that has an operating agreement, you just use theirs. I mean, these are very fact-specific documents. You should really be paying attention to all that boilerplate and all those terms to make sure it really is what you want. Don't go with these one-size-fits-all agreements, because inevitably they don't work. And also too, once you have these documents, you got to follow the rules. Because if you say, oh, well, this one time, yes, we have these transferability restrictions, but we're just going to let it go. it's that nothing good comes of that. Usually it's always then, well, down the road, you decide you're going to follow the rules for one person and not the other. And now there creates tension and disagreement amongst the folks. Or maybe someone kind of changes their mind after the fact to say, now I want to kind of retroactively try to enforce these provisions. It can just get complicated. It can get messy. It can result in everybody hiring lawyers and having to go to court, which nobody wants aside from the lawyers themselves. So I would say you have these documents for a reason. You got to abide by the rules. And even kind of similar to what I said with estate planning, these are documents too that you can periodically revisit and update. So as new people are coming in and taking over management, or you're having more members, come back and take a look at these documents. It's really important if this starts off as, maybe it starts off as a single member LLC, so it's really just you. So maybe the rules are really simple and really straightforward in these agreements because it's you. But the second you start bringing in more members, you really got to update and say, okay, well, I didn't really have a whole lot of transferability restrictions in because it was only me. Now there's somebody else involved. We really need to update those provisions. So again, periodically taking a look at these and not just do it once and never look at them again.
So I think it says it's 1 o'clock. Why don't you leave this slide up so people can read it? I think we've covered some of this already, but I want to make sure that there's any, well, first of all, evaluations, right, Sylvie? we
Thank you.
You're going to
I'm
put
going to post in the chat an evaluation that helps us. And so if you could please do that before scooting off, that would be very helpful.
And we can stay on a few more minutes if there are people who have some last questions on the business entity. I haven't seen any.
There was a question about primary property for the Medicaid. So if there is room for that, that would be a question that was.
What was the question?
Is the primary property sometimes exempt from Medicaid asset rule?
I don't know what the primary property means.
So in Maine, like if you're living there, if the person's living there, is that exempt? That's what the primary property.
Well, that would be the residence then, right?
Yeah, I think so.
So then, yep, so long as you're living there or your spouse is living there, the property is non-countable as far as Medicaid is concerned.
And as long as it's below that threshold, whatever the threshold is in Maine, which you can find online.
Correct.
And then there was one other question about, can you basically swap out stuff in assets in an irrevocable trust, or it's like those assets that get put in, they're stuck in there and you can't, swap them out for a different property, for instance.
So I'm going to give the standard lawyer answer is it depends. It depends on what the trust permits you to do, because the trust document itself will say exactly what you are and aren't permitted to do. But a lot of times with these irrevocable trusts, there is a provision that allows for substitution of assets, so long as the asset you're substituting in is kind of equivalent character and value of the asset you're taking out. So kind of if you're leaving the trust in a similar position, then it's okay.
I'm glad I asked because I thought it was no.
Well, again, depends on the trust, but some of the irrevocable trusts that we draft do permit substitution of assets.
Okay. Any questions on business entities? I think we're otherwise gonna need to wrap it up. As we mentioned before, getting a good attorney, that's the best way to get the answers for your particular issue. And we'll see all of you next week for the last session of the webinar series. Thanks for coming.
Thanks, everyone.
Thank you, everyone. Thanks, Allison.